Felony theft? Is there a way to potentially get your case dismissed? Hi, I'm Jeff Hampton with the Hampton Law Firm. I want to welcome you to our YouTube channel. And today I want to break down Texas law as it relates to theft. What makes it a misdemeanor? What makes it a felony? What can you do to prepare yourself to defend your case and get your life back? And by the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. All right, now here's the thing. The criminal justice system breaks down the offense of theft into two parts. Very similar to most other offenses, misdemeanor theft and felony theft. Obviously, misdemeanor crimes are less serious than felony crimes, but most people don't understand the difference. Like, what makes my theft case or my family member's theft case a misdemeanor, or what makes it a felony? Well, one of the things we're going to look at here today is one of the major issues that determines whether or not a case is a felony or a misdemeanor when it comes to theft is what was stolen, number one. Number two, what was its value? Okay, what was its value? So let's break into this for a second. Well, since we're primarily focusing on felony theft, we're looking at any item that has a value of over $2,500. Okay, $2,500. That's kind of the line that we're looking at here. So the most important factor is this value. And as you can imagine, some people want to attach more value to certain things than others. So that will be one of the defenses we'll discuss here in a few minutes. But if the value of the merchandise is a minimum of $2,500 and up, you could be looking at a minimum of a state jail felony offense. So $2,500 to $30,000 is a state jail felony, punishable by up to 2 years in prison and up to a $10,000 fine. You get to 30 to 150, talking about a third-degree felony, punishable by up to 10 years in prison and up to a $10,000 fine. 150 to 300 is a second-degree felony, up to 20 years in prison and up to a $10,000 fine. And over $300,000, you're talking about a first-degree felony, technically up to life in prison, okay? Now, I'm going to give you some funny ones here. Did you know that there are certain things, we talked about it depends on what you steal, right? Well, one of the things, if you're caught trying to steal sheep or other livestock, goats, sheep, cattle, you can be hit with felony theft charges. Now, maybe this only applies if you live in West Texas or something. I don't know, but I'm just telling you, that's what the law says. So listen to this. Stealing less than 10 head of sheep, swine, or goats, or any part thereof under the value of $30,000 is a state jail felony, all right? I doubt anybody's going to face that, but I told you I'd tell you what the values are. But so that's one of those. The other one is, and unbelievably, I've actually faced this situation, someone robbing a grave. Literally, we actually represented someone trying to desecrate a corpse, literally going in there trying to take something that they thought was of value. If that happens, any part of a gravesite that's taken, you could be facing a minimum of a state jail felony charge. But let's get down to the main thing here. Nobody's going to be facing those charges very frequently. Here's a big one. What if it's a precious metal? There are a lot of people, especially in the North Texas area over the last few years, where people's air conditioning units have been raided, or they'll get up underneath people's cars and they'll take the copper out of the vehicle or the air conditioning units. That stealing of that copper or those precious metals, whenever there's enough value there associated with that, you could be charged potentially with a felony. And then here's one, it doesn't matter what the value is. What if you steal a firearm? What if there's an allegation that you intentionally or knowingly permanently deprived the owner of their firearm? That is a state jail felony offense. Doesn't matter if the firearm was worth, $100. Doesn't matter what the value of it was. If you try to steal a gun from someone, it is a state jail felony. And so these are all important just to consider, because many times those are the two main issues you're going to be looking at is value and what is the actual item. Now, if you already have a criminal record and you're charged with theft in Texas, here's another issue. Previous convictions for theft elevate you very, very seriously. If you have 2 prior, or even shoplifting, little minor convictions, and the judges up here used to joke about this, but it's not really funny, you can actually now go steal a piece of bubble gum at a store worth almost nothing, and you can be charged with a felony. So they add up those strikes against you. Multiple prior theft convictions can now, anything you steal for the rest of your life or family member steals for the rest of their life can now be a felony that's charged against you. There was a case that went to trial up here in the Tarrant County area where a lady stole shoes, like shoes from Payless shoes, and it went to trial up here and she got like 18 months in prison. Yeah, because she had two prior misdemeanor convictions. So it's important to understand that. Now, what are your defenses? All right, you're not going to be surprised to see that some of the defenses are very similar to what I've already spoken about. So if you are facing or you or a loved one is facing a theft charge, number one, you need to break down value. Okay, so think about this. What if you're not sure? What if someone is claiming that their car, 25-year-old car that doesn't even run, what I used to call, my dad would call it an old beater, sitting in the front yard. It doesn't drive, can't even start it. But they're claiming this thing's worth $3,000. Okay? It's worth $3,000, but it won't even start. It's got dents all over it. They get some sort of kind of thrown together little handwritten estimate. They send it to the district attorney's office. Okay, what's the real replacement value of this vehicle? You understand if your attorney is aggressive and looks into this, it's not based upon the subjective value of the alleged victim. It's based upon the market, the replacement value of that item. So one of the number one things that can be done is your criminal defense attorney needs to really tear apart the case and determine, is value able to be proven? And remember, the state of Texas must prove it beyond a reasonable doubt. So one of the tactics that can be used is to go and look at similar items that are similarly in that condition and situated that can be used to show estimates that it's not of that value, and that doubt can be used to give you leverage on your case, okay? Secondly, what if there was no intent to permanently deprive? We've had instances where there was a history of conduct between the two parties where they would let each other borrow stuff. But now all of a sudden one of them gets mad at the other one and they say, you know what? I never said you could borrow that. And then they call the police. The police just believe them. And what we are able to do is provide context, show all of this. Look at all this. He let him borrow this, that the other person let the other person borrow this. If there was no intent to permanently deprive the owner of their property, there is no theft, okay? So what if we're talking about felony theft here? You say, that's me. You're talking about my situation. How do we deal with it? Well, every felony in the state of Texas has to be indicted by a grand jury, including your felony theft. So if these type of fact scenarios apply to you, I want to encourage you to contact our law firm. And one of the things we can do here at the Hampton Law Firm is evaluate your case and look to put together an evidentiary packet to be presented to the grand jury. The grand jury is a panel of citizens that listens to evidence, and they can do one of three things. They can keep your case as a felony, they can lower your charge to a lesser charge down to a misdemeanor, or they can no-bill your case. And a no-bill means your case could potentially be thrown out. But this usually happens within about the first 30 to 60 days after the date of your arrest. So here at the Hampton Law Firm, we would gladly be willing to give you a free case analysis and a consultation. And if you would like to give us a call, maybe your case is in the North Texas area, don't hesitate to contact our office at 817-877-5200. And I promised you if you waited around to the end of this video, I would give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Click the link down here below. I'll send it right over to you. And thanks for joining us today. If you like what you've heard, like our video, subscribe to our YouTube channel. We'll be happy to send you more great content just like this. All right, have a great day. Thanks for joining us.